Buenas tardes, good afternoon. This is the first special session. Today is Monday, February 28, 2022, approximately 1:50 p.m. here in the Senate chamber. And before I ask everyone to please rise for a moment of silence, I would like to respectfully ask that in the midst we think about the turmoil and the hardship that's going on in the Balkans, or in this case in Ukraine, as there are some terrible things happening over there. I also learned not too long ago that there are some of our fellow citizens from the CNMI who have been called to duty to serve in this very conflict. So, in the midst of all the situations and the problems that we have here in the CNMI, I think there's a bigger issue that's happening globally, especially in the nation of Ukraine. So, I ask that we keep them in our prayers as we rise for a moment of silence. At this time, the chair recognizes the clerk to please call the roll.
Senator Cruz,
Here.
Senator De Leon Guerrero,
Here.
Senator Hoku, Mr. President,
Gaye.
Senator King Neighbors,
Here.
Senator Manglonya, Senator Kidua, Senator Sablan,
Gaga.
Senator Santos. Mr. President, all 9 members are present.
With 9 members present, we have a quorum to conduct this session. And let the record reflect that Senator Carl King Neighbors is appearing before a virtual platform today. So with that, before I recognize anybody from the gallery and the public for comment, I want to clarify with the clerk, by rule, did your office request anything by email, phone call, or written to request for public comment to offer for today's session?
No, Mr. President.
Did you or did you not?
Not received any.
Okay. Despite that, I'm going to overrule that and allow for public comments to be presented in reference to the agenda before this body today. So at this time, please, I welcome anyone and kindly state your name for the record. This is Masi.
Test. Can everybody hear me? Thank you, Mr. President, for allowing public comments today. Good afternoon. My name is Selena Babata, and I'm a member of the 22nd House of Representatives. I want to state for the record that I denounce the proposed rules adopted and passed by the Senate Joint Committee of Executive Appointments and Governmental Investigations and the Committee on Judiciary, Government Law, and Federal Relations, respectively chaired by Senator Francisco Q. Cruz and Senator Carl King Neighbors in their joint committee held last Friday in this chamber. And further state that these proposed rules are not congruent with the applicable statutes and a complete betrayal of the CNMI Constitution. The OGA, or the Open Government Act, mandates that the public be afforded the right to make oral comments during the public comment period. Written comments are not sufficient. Even if COVID-19 concerns were applied, the CDC guidelines and the House and Senate policies allow for public comments. For example, today in the lobby, we are making public comments. These proposed rules were adopted in violation of the letter and spirit of the Open Government Act, which states Title I, Section 9904, meetings declared open and public. All meetings of the governing body of a public agency shall be open and public to all persons shall be permitted to attend any meeting of the governing body of a public agency except otherwise provided by this chapter. The governing body shall afford all interested persons an opportunity to submit data, views, or arguments in writing on any agenda items. The governing body shall also afford all interested persons an opportunity to present oral testimony on any agenda item. Emphasis added. The governing body may provide for reasonable administration of oral testimony by rule. Furthermore, Title I, Section 9907, ordinances, resolutions, rules, regulations, etc., to be adopted at public meetings, sanction notice. No governing body of a public agency shall adopt any ordinance, resolution, rule, regulation, order, or directive except in a meeting open to the public, and then only at a meeting the date of which is fixed by law or rule, or at a meeting of which notice has been given according to the provisions of this chapter. Any action taken at meetings failing to comply with the provisions of this chapter shall be null and void. The Open Government Act expressly prohibits the lack of transparency that was exhibited in the passage and adoption of the Senate rules on Friday, February 25th, 2022, during the Joint Committee meeting. These proposed rules were handled as if they were a threat to national or Commonwealth government security and were treated as secret document. The fact that a recess was called to accommodate Senator Justo Kituga's request for a copy of the final amendments to the rules during the Joint Committee meeting last Friday demonstrates that the final proposed rules were kept secret from him as well, and he is a sitting member of both committees, not just one. Because of this willful violation of the Open Government Act, there can be no other interpretation than the rules that were adopted by the Joint Committee are null and void pursuant to the law. This body cannot adopt and pass these proposed rules because it is not properly before this body. In addition, when the Joint Committee adopted and passed these rules last Friday, they violated the constitutional provision that the Legislative Bureau is the only entity tasked to assist the legislature. It is their raison d'etre. Article 2, Section 17 of the CNMI Constitution, B, states the director shall employ all necessary staff other than personal staff of the members of the legislature pursuant to budgetary allocations. The staff members shall include legal counsel and other administrative staff. The Bureau, Article 2, Section 17C, the Bureau shall provide all required services to the legislature in connection with the duties and responsibilities during sessions and committee meetings. It shall maintain all records, files, library, and other documents of the legislature. The fact that a special counsel was specifically hired to draft up these rules and personally participated as the Joint Committee's counsel during their meeting last Friday instead of the two highly capable Senate counsel is contradictory to and is a betrayal of our Constitution. Why even have a Constitution if the Senate can arbitrarily subvert its democratic principles? There is no ambiguity in the Constitution that the Bureau counsel should never be replaced by a private attorney in its role of assisting any Senate committee, and private counsel should not be utilized as the official counsel in any official Senate or committee meeting. Even during the JGO investigation hearings, we respected the Constitution and utilized only House legal counsel.
Ms. Babota, I ask that you
I
wrap up
question
your comments.
and I ask who is providing direct or indirect funding for the special counsel, Mr. Joe McDoulet? Is it the governor? Is it
Mr.
the
President,
Secretary? Or is
I
it
cannot
the
hear what she's
legislature?
saying. Short recess?
Can you check your mic one more time? And I ask that we finish your comments so that we can move on to the next testimony.
Should I go to the end? Should I go to the end? Are you willing to read it? That you're giving your time? No? No? I'll go to the end. Thank you, Mr. President. In the interest of time, I will skip many of my comments. So thank you for allowing me. These rules are so lopsided and unreasonable that they violate the fundamental tenets of due process. These rules are intended to preclude the House of Representatives from having adequate opportunity to plead its case on the merits. Antes do fatto magi, ihadzi po presentas na causa para isang hilo na guma. Esta in hilok lapes niya, esta in titik papet niya, esta in geddi kaday niya, esta in tep patot niya. Only a cheater, afraid of the rules of the game, stacked the decks with 5 aces.
Ms. Babota,
It is clear that
I
this Senate
ask
body will
that
prosecute the governor.
I ask that you wrap up and refrain from any reference to any demeaning words. That's all I ask.
It is clear that the Senate body will prosecute Governor Torres on a set of rules that are unlawful, unconstitutional, and more importantly, slanted in his favor. The fix is in. These rules basically create a theory of how Governor Torres is not guilty and then work backwards from there, creating such arbitrary nuisances that if the House clerk doesn't paginate the documents or request for and get the permission of the Senate President in order to submit paper evidence, can possibly terminate the entire proceeding. I am disappointed, but I am not deterred. Si Diyos masi, zan buenos dias.
The floor remains open. And again, kindly state your name for the record. And I ask that you limit your comment to 3 minutes. Thank you.
Hafide Tiro, Casalelia Menko, honorable members of the Senate. My name is Sheila Jack Babauta, and I'm here to provide public comment on the Senate impeachment rules. I'm here in my official capacity as a Precinct 4 representative in the 22nd House of Representatives. It's been 47 days since the governor was impeached in the House, and although I'm grateful that there are finally impeachment rules made public, I want to state for the record that these rules are clearly biased, and I'm extremely disappointed in the process in which they were adopted, lacking transparency and sufficient notice. There are 2 issues I'd like to highlight. The first being Rule 5, burden of proof at hearing. Requiring clear and convincing evidence as the standard of proof is unreasonably high. This is not a criminal case. Even the CNMI Supreme Court does not view the Senate impeachment trial as comparable to a civil or criminal proceeding. It is uniquely a legislative and political function. As stated in the letter signed by Chief Justice Castro and Associate Justices Enos and Mangonia on January 28, 2022. The clear and convincing standard of proof is higher than the standard that would have been used for the Governor Fitio trial. The clear and convincing standard of proof is even higher than the standard used in the Trump impeachment trials. Why? Why are we setting the standard higher than the one used to impeach the President of the United States? There is no standard listed in our CNMI Constitution, and there's no standard listed in the US Constitution. So the unreasonably high standard of clear and convincing evidence is clearly meant to work in favor of the governor. The second issue I'd like to highlight is the limitation on representation and use of legal counsel. limiting the House prosecutors to only the House Speaker, or if he declines, only the chairman of the House Impeachment Committee, or if he declines, only the House member selected by the Senate President, is simply unfair. The House, which has the burden to prove, only has one prosecutor. The governor, who has no burden of proof whatsoever, has no limitations on his counsel. The House prosecutor is not an attorney, and even with the assistance of two House counsels, only the House prosecutor can ask questions, raise objections, make motions, and make the opening statement and closing argument. The governor's counsel will be an attorney with training and experience, and again, will have no limitations. It's clear that these rules are limiting our ability to present a robust case to conduct a fair trial. This impeachment process will set precedents. Because this is a first in CNMI history, future CNMI legislatures will look to us, the 22nd legislature, for guidance on the process and rules. This is not the example we should be modeling. It is problematic and one-sided. It exerts a chilling effect, ultimately discouraging any future House of Representatives who might want to pursue oversight of the executive or judiciary branch, deterring the House from exercising its clear constitutional right to initiate impeachment proceedings. The emphasis of the impeachment process is on the significant effects of the governor's conduct, undermining the integrity of office, neglect of constitutional duties and oath of office, abrogation of power, and abuse of the governmental process. I urge this body to make appropriate amendments to produce impeachment rules that are fair to the process and to the people. Thank you.
Si Representative Sheila Bauta. The floor is still open, and again, please limit your comments or your testimony to 3 minutes and state your name for the record. Thank you.
Thank you, Senate President. Hafaday Jantiro, good afternoon to our honorable senators and the viewing public. I'm Representative Corina Magofnia, and I am here to represent the voices of my constituents from Precinct 3. The people of our Commonwealth have the right to have us, the House of Representatives, conduct a fair trial as stated by our Honorable Speaker, Edmund Villagomez. It is imperative and of utmost importance that we, the people, remind our honorable senators that you are sitting in here today in that very prestigious seat. Why? Because we, the people, elected you. We elected you to represent us alone, and no one else. We, the people, must remind you, our honorable senators, that you took an oath and swore to uphold your fiduciary duties, but most importantly, to do what is right and in the best interest of our people. Now, let me ask you all this. Are the rules of impeachment, as it stands today, for the impeached official Governor Ralph Torres, for the best interest of our people? I think not. And I can assure you and guarantee you that many of your constituents who elected you into office feel the very same way. So ask yourselves again, Hadi un representa, itautauta par igubetnu. I sure hope you know the answer to this question, because I know our people are watching and listening to see who your loyalty is to. Now, with regards to the impeachment rules, which was adopted last Friday, let's do a quick comparison between our former governor, Benigno R. Fitio, and Ralph Torres. These were the rules that were created for Governor Fitio, a total of 18 pages consisting of 24 rules. These are the rules for Governor Torres, which consists of 28 pages consisting of 44 rules. I'll let you marinate on that while I'll talk about the rules that are just so unbelievably unfair and unconstitutional. Let us be open and honest that there is no ambiguity to what Rule 9 truly entails. The proverbial forest and the trees analogy. For those in attendance who aren't familiar to this phrase, it simply means that we must look beyond mere words to see the hidden message being conveyed, also known as the author's overall intent. Here I noticed an almost comical, if not for the serious matter before us, unreasonable, unconscionable demands on one of the most important, if not the most important subject matter herein. The committee has daring initiative through purposeful acts of their own managed to create a rule that solely benefits, favors, comforted, and or coddled the impeached official Ralph Torres with most of favorable terms and conditions to an almost guaranteed success outcome. Basically, the Senate impeachment rule seeks to first find a way to remove the impeachment prosecutor, Rule 9, Section D. If all House impeachment records and transmittal thereof is successful and removal of said impeachment prosecutor failed, the second fortification is to have the House impeachment record automatically stricken, and only the impeachment matter, whatever that is, shall proceed to Senate, Rule 9, Section C, number 2. And to sweeten the pot, an added measure also prevents the impeachment prosecutor from appearing on the Senate hearing and proceeding. If all else fails, i.e., the impeachment prosecutor made it through, the House impeachment record is properly certified, and impeachment prosecutor is still given the okay to attend the Senate hearing and proceeding, the third and final last-ditch effort takes the cake and tailored only to the countries such as China, North Korea, and Russia. Let the impeached official strike any part or the entire House impeachment record or supplement any part of the entire House impeachment record as he so chooses. Rule 9, letter G. In layman's, no prosecutor, no records, and if all fails, let the impeached official decide. Where is the justice, fair, and honor? And what message are we sending to his very own staff and agencies who are under his administration? That the record that he submitted to the JJO committee is unreliable, lacks integrity. Also, Rule 9 fails to provide what mechanism is to be provided to the House prosecutor to contest the impeached official's request. Nothing. Todd's at. So I ask again, where is the fairness and respect for our people? Senators, what is your message to our people? Now let's go back to the comparison between Governor Fitto and Torres.
Ms.
24
Magofnia,
rules
I
for
respectfully
Fitto,
ask that you
44 rules
wrap
for
up.
Torres, differences of 20 rules. Why is that?
Ms. Magofnia, sinabi Vice
Okay, I'm
Senator.
wrapping up. Give me
Thank you.
1 minute, please. Reduce Masi. Let me just wrap up.
Mr. President,
Proceed.
I don't like this, Mr. President, that we're trying to leave when the speakers have started out saying they were
Senator
given
Paul,
no opportunity.
I never recognize you. Why are you intervening? I never recognize you on the floor. We're under public comment.
I'll wrap up, I promise. So to the people of the Commonwealth,
Mr.
the
President,
Senate
out of
has
order
given
na si Senator po.
very stringent, unconscionable terms and conditions that caters to one man and one man only. Nevertheless, Ralph Torres is not a man with any significant means of public contributions aside from the federal handouts under the people's name. That may be his true worth. A true and honorable governor status belongs to one who selflessly contributes to his advancement to his people and one that does not try to take all the credit for all the good things that happens in his commonwealth. There is no I in team. Sidus Maasi and Giliso.
Thank you, Representative Magofnia, and the chair calls for a short recess. The gentleman on the microphone, please state your name for the record and limit your testimony to 3 minutes. Thank you.
This one?
You're on.
Good afternoon, Mr. President, Committee and Senate. My name is Alden Vincent Semen. I'm here to speak as a private citizen and to represent those that are in fear to speak their mind in public. So here we are. We're about to change the rules on the 11th hour. What, if anything, is wrong with the previous rule that was implemented during the impeachment of former Governor Fitio? Are we changing the rules now so that the ruling party of the Senate will have the upper hand? Where is the justice in that mentality? Is this the legacy we want to leave for our children, our future leaders? That if we don't like the rules because it doesn't benefit us, we can change them on a whim. That it's okay to lie, to cheat, to steal, because we have the majority. What the heck are we doing? Your job is to protect the best interests of the public, not the parties. You are playing political tricks at the expense of the people whom you promised to serve while you were campaigning. So remember that this seat that you're sitting in does not belong to you. And it definitely does not belong to the parties. So stop BSing the public and stop manipulating the CNMI Constitution that you all sworn to uphold and protect. Esta mampus no ninipus amzo. Nisiga manikondo. Ada sa timan ma tigagas ti siya itawtogi gisanizong. Pes basta man mamagaga. Ang kita si Janmizo man mafagaga na pes basta mafagaga itawtogi ni Lagmizo por protehi. Sa parago tigagazo. Pes sa Janmizo no fagagagay. Okay? The people out here are not a bunch of cattle
Sir,
to treat as
I
cattle.
must interject that you limit
So you do your job.
your testimony with regards to the order of business. Thank you.
That's all I got to say.
Okay. Therefore, I'm gonna
Mr. President.
for a short recess. the floor leader to offer a motion for adjournment.
Thank you, Mr. President. At this time, I'd like to offer a motion to adjourn today's Senate session. So move.
A motion by the floor leader to adjourn this session subject to the call, and it's been seconded. All those in favor for motion on the motion to adjourn this special session, please say aye.
Aye.
All those opposed say nay. Motion carries. The special session stands adjourned subject to the call. Thank you.